terminal disease or physical incapacity can only be decided and determined by a doctor, a medical practitioner. The functionary who acted in this matter, Mr. Fraser, who was the National Commissioner at the time, on the papers, not in dispute, is not a medical practitioner. He has no medical knowledge, expertise. He's not in a position to make that decision as to whether any particular inmate is suffering from a terminal disease or condition or is physically incapacitated in the manner required by the section. You, with respect, can take judicial cognizance of the fact that Mr. Zuma is on the public stage just before his admission to prison. He conducted a very well-publicized press conference at his home in Nkandla without a mask, flanked by his legal representatives. He was in a, if I may say so, combative mood. He was defiant of the Constitutional Court to the end. There was absolutely, and is absolutely, no indication that he is physically incapacitated as required by 79(1)A. After his release on medical parole, again well publicized, he visited a casino in Durban, Justice, in order to meet political allies. Absolutely, he was seen leaving his vehicle, going into the casino, coming out with files under his arm, etc. Absolutely no indication of physical incapacity.
And aligned with what our learned friends for the DA have said, we say that Mr. Fraser had no power to override or ignore the medical board. And second, if he had that power, he second-guessed very irrationally. And thirdly, my lord, if one looks at his impermissible reasons in the answering affidavit, things go from bad to worse on the irrationality front. Let me start with the first point. We say Mr. Fraser's decision was unlawful because he has no power to second-guess the board's determination of terminal illness or severe physical incapacitation. Mr. Fraser has not a jot of medical experience, none. And we know that from Mr. Zuma himself, because Mr. Zuma admits that the National Commissioner, in his words, is not a doctor to have been expected to make medical conclusions on my medical health, my lord.
The National Commission never overruled the medical parole and advisory board because the functions of the MPAB or of the parole board and that of the National Commissioner are different. In terms of the law, the functions of the MPAP is to make a recommendation to the National Commissioner. And the decision on whether to grant medical parole or not lies with the National Commission.
The applicants have not demonstrated urgency in seeking an urgent review of this particular medical parole decision, and also on the basis that there are no real consequences of the nature that they wish to achieve through this application, given that Mr. Zuma now qualifies for an ordinary parole. So what they are asking you to do is something that invariably has no practical legal effect, to the extent that the person they wish to have incarcerated will in fact be eligible to be on parole as soon as is already at that level where is eligible for it. The reason why this application has been brought by these political organizations is to pursue a political agenda. They do not claim, while they are claiming that they have human rights, interests. Here they are arguing in court, asking for the rights of Mr. Zuma to be violated. One of which is the right to privacy, rights to is the privacy of his medical records, to be splashed in newspapers and to be made a subject of political rallies and other organizations that they are interested in having.
Under Section 75(7), the Commissioner was entitled to take into account, of course he did take into account the Section 79 documents. That's not a secret. He says so himself. That's why he says read with Section 79. But the decision itself was taken under Section 75. And he explains this so clearly, my lord, in his reasons. He says, here's the sequence, it's very simple. He says there was an application, he was not involved in that. The application was considered by the board. He was not involved in that. And then it was rejected. He was not involved in that. How did he get involved? His involvement was triggered by the head of prison, who said, I am concerned because the board has rejected the application and this person is clearly ill and we cannot accommodate the person. Then he says, he doesn't say, oh, well, I'm going to overrule them, like my learned friends want you to believe, my lord. No, he says, okay, I'm now going to revoke the delegation under section 75(7).